Doggo in relation to Makeality Ltd and City Doggo Ltd.
Yes, Mr. Edinburgh.
My lords, I and my learned junior Annalise Monshine appear for the claimant, which is the appellant in this matter, and Nicholas Saunders, one of his Majesty's counsel, along with his learned junior Mark Wilden, appear for the defendants, who are the respondents in this matter. My lords, you ought to have three bundles: a core bundle, a supplementary bundle, and an authorities bundle.
Yes, thank you.
There ought to be nothing else, save for the fact that my Lord Justice Arnold indicated that he'd like us to consider a further case, which was the referral case. I didn't know whether you already had copies of that, so
no, but it's not necessary to look at that case unless parties think it might be resisted. It just occurred to me that it might be germane simply on the basis that it's a recent authority on direct effect.
My lord.
But it doesn't necessarily follow that it's necessary for us to look at it. I just thought
no, my lord.
It might be helpful. That's
all I was going to say is I've handed out copies in case it was necessary. That's all I was going to say.
It's up to you, Mr. Eden.
Very briefly, this matter concerns an allegation of trademark infringement and passing off, and has been brought in the IPEC, Intellectual Property Enterprise Court. You'll find the relevant pleadings in the core bundle, and as is normal, after the pleadings were closed, there was a CMC, and that occurred in September of last year. And at that CMC, the respondents made an application to transfer the case to the IPEC small claims track. In support of that application, there were two witness statements from the respondent and a witness statement from my instructing solicitors that resisted that transfer. After the CMC, there was duly an order and judgment by which His Honour Judge Hacon ordered the transfer to the SCT, and that order and the judgment are contained, of course, in the core bundle. On appeal, there are two issues, the first of which is ground one, that the judge was wrong as a matter of fact to make the transfer, and secondly, that as a matter of law he was wrong to make the transfer because he ignored the point about the fact the parties are legally represented and the inability to recover appropriate costs in the SCT. I was going to concentrate upon ground one, if I may. With respect to ground one, the relevant law is contained in JALA, which is in the appellate bundle, sorry, in the authorities bundle, tab 3, and the relevant part of the judgment starts at page 45 of the bundle, paragraph 27 of the case. I was going to deal with this quite quickly. The long and the short of it is it can be summarised in paragraph 28, which is on the next page, which is in such circumstances as this, when I'm endeavouring to appeal the CMC decision, which is an exercise of discretion, what I need to show is that the judge took things into account that he should not have done, so irrelevant matter, or he failed to take into account things that he ought to have taken into account, so omissions, or he exercised his discretion clearly, wholly, wrongly. And of course, when you look at that ground or that element, you have to bear in mind that there's a wide ambit given to any decision by a first instance judge. So therefore, that obviously is quite a high hurdle, as is expressly stated in paragraph 28. While we're in JALA, if we turn the page to page 30, this will become relevant later. After the relevant quote there from the overriding objective, he talks about the administration of justice and the effect upon other court users. Now, dealing with the transfer application, this is governed by CPR Part 26, Rule 13, and it's in the White Book for your note, which is at Volume 1, page 778, but it's also contained in the judgment, and as that's going to be the focus of our attention, it's probably best to go there. And in the core bundle, you'll find behind tab 5 the judgment, and on page 55, which is the second page of the judgment under appeal, you see that the judge has set out the relevant provisions of CPR 26 in paragraph 5. And it goes over the page. But in this case, the focus is upon subparagraph A, the financial value, if any, of the claim, and subparagraph C, the likely complexity of the facts, law, or evidence. It is also pertinent to look at subparagraph F, which is the amount of oral evidence which may be required. In some senses, that's a subset of subparagraph C because it goes to the complexity of the evidence. In the context of this case, in particular, because the transfer is being made from IPEC to the IPEC SCT, it's pertinent to look at the IPEC guide, and you'll find that in the authority bundle behind tab 13, and the relevant part for today's purposes may be found on page 289.
Para 3.3.
Correct.
Thank you.
The IPEC multi-track or small claims track. And it's all contained within that page 289. I was just going to pick out highlights, but the broad speaking points are that the claim ought not to exceed £10,000 in value, that's paragraph 3, and in paragraph 4, it in essence ought to be a case of low complexity with little cross-examination and ought to last no more than 1 day. Now, that last point is given more clarity if you actually look at the guide to the IPEC small claims track, which may be found on the previous tab behind tab 12. And in particular, if you go to page 264, allocation to the IPEC SCT, and the third paragraph there, and it's the second sentence, a claim where both liability and amounts quantum cannot be resolved within 1 day, including judicial reading time, are usually not suitable for the IPEC SCT. For example, cases concerning the validity of trademarks rather than infringement of a trademark are unlikely to be suitable. So what I take from that paragraph is that when you're looking at the time period of 1 day, that is everything, and it comprises at least three things. One, the time necessary to determine liability. Two, the time necessary to determine quantum. And three, the judicial pre-read-in time. Now, the IPEC SCT scheme was introduced by an amendment to the civil procedure, and we have the explanatory memo to that SI, and you'll find that behind tab 15 in the authorities bundle, starting at page 328. Explanatory memorandum to the Civil Procedure Amendment Rules 2012, and then you turn the page to 329. You see the policy background commentary, but what's particularly pertinent to us is paragraph 7G, which is on page 331, and this talks about the introduction of the small claims track, and might I ask you to read that paragraph. And my lords, you can see from that again it reiterates the points about the SCT is appropriate for the lowest value cases. There's also a point there halfway down about the small claims track is expected to benefit those claimants currently deterred by the cost of bringing such a claim within the court system. So that presumably is aimed at those claimants that are not as well funded as other claimants. It continues, it will deal with the lowest value copyright, unregistered design and trademark claims and will be quicker and cheaper than the current options. Carrying on, it is expected to be of greatest benefit to small and medium enterprises and entrepreneurs with straightforward claims, for example, the use of photographic material without consent. And that point is also picked up again on page 338, where in the fourth paragraph it talks about, this is from the evidence that was submitted in favour of this amendment. In my view, there is an unmet need for justice in this regard. One can cite many other examples beyond those mentioned by the FSB. For example, a journalist whose articles have been reprinted without permission might have a claim for a few £100. A photographer whose photographs have been downloaded from the internet and reproduced without permission might have a claim for a few £100. The point there is that those examples, of course this is only by way of example in the evidence that was submitted, what's in issue there is really only one thing, naming what's the appropriate quantum for the infringement. So in those copyright cases, there doesn't appear to be any real issue with respect to title or subsistence or the infringement. What really is an issue is just how much should the wrongdoer pay, and the indication is it should be a few £100. And to make good that as well, if you go to the previous page, 337, under the heading Rationale for Intervention, in the first paragraph, the third sentence, It says, however, there is evidence to suggest that there are many IP claims which are at the lowest end of this value, well under 25,000. That was, of course, in the evidence gathering stage, and the cap was changed later on, and are of the least complexity that are still not suitable to be heard under such a procedure.
Sorry, can you explain for me, please, the point about the cap changing?
Yes, the 25k here, it was unclear to start with at what level the cap should be set with respect to the financial value. And a number of different values were put forward. At one stage it was thought to be 25, at another stage it might be 5, and in the end the Rules Committee settled upon 10.
But that's not a cap.
It's a cap in the sense that it's a suggested upper limit. It's not,
Yes.
it's not a hard ceiling.
Right.
And where are we on the small claims track and fast track in general litigation now?
With respect to intellectual property?
No, just in other civil proceedings.
I think it's 5,000.
5 and 25, or 10 and 25.
They're all low.
Yeah.
I think it's
I
5.
just,
But for IP it's 10.
yeah.
I thought it was increased across the board. My recollection, which may be faulty, is that when the SCT was originally introduced in IPEC, it was £5,000, which was the same for general litigation, and subsequently was increased to 10 in line with other cases.
Fine, I'm sorry, my lord, I've never done anything in small claims track in another subject matter, hence my ignorance. But for IP, it's
Don't worry,
definitely
sorry, it was a sort of slightly left field question.
Yes.
My lord, we think it's 10, 25 and 100, but we'll just double check the rules.
Thank you very much.
In the skeleton argument of the respondents in this matter, at paragraph 19, they summarise it in the way that this scheme, the SCT, is to improve access to justice for those for small and low value claims. But actually, I would amend that and say that the SCT scheme is to improve access to justice for those with limited means for small and low value claims. And that extra qualification, in my submission, you get support from the various memorandum and what have you, about the deterrent by the other fees that would normally be incurred. And so therefore the whole thing is designed for litigants who have less financial support behind them for the lower value, least complicated claims.
Well, those of moderate means may be deterred by huge bills of costs.
Yes.
So, and in other areas of civil litigation, there are low cost or no cost schemes imposed by the rules. You could be a multimillionaire and you'd still be caught by those. So I wonder what the authority is for the proposition that this is really not just for those with small claims, but for those with limited means to pursue the small claim.
Just 1 second. Well, the support that I would put forward for my proposition, my lord, is the expansion memorandum, which is
Yes.
behind 15,
Right,
paragraph
thank
7G, and the middle part of that paragraph.
Yes. Right.
That's as far as I'm going to take that point.
Yeah. Okay.
Now, if I may, I was going to then look at actually what this case involves from a legal and factual point of view, because of course that is relevant to the complexity or otherwise. And to that end, I was going to take you to the particulars of claim. They may be found in the core bundle behind tab 6. And the particulars claims start at page 64. And working our way through it, if you turn the page to page 65, you can see that here there is an allegation of joint tortfeasorship. This is commonly pleaded in intellectual property matters because the first defendant here is a corporate entity and the second defendant is the director of that corporate entity, and it's often done to ensure that you've captured everybody who may or may not be responsible for the wrongdoing. If you turn the page, starting at paragraph 11, you can see that there's an outline here of the claimant's mark, the trademark upon which it relies. Paragraph 13 is a fairly standard pleading that the mark is valid and subsisting. So the subsisting bit basically just means the renewal fee is being paid. The valid pleading is you obviously need a valid trademark to get trademark infringement up and running. But in this case, it is in issue whether or not the validity of the mark is there. It's not been raised by way of a formal counterclaim, but it has been raised in the defence. I'll deal with that in a little bit more detail later. Then if you proceed onwards, you see there's a heading, distinctiveness and reputation. And the long and the short of all this is that pretty much everything's been put in issue. So all the things upon which the claimant relies to say that the mark has distinctiveness and also reputation, they're strictly two different things, even though the evidence commonly goes to both points. That's been put in issue. Then if you turn the page now to page 67, and I'm looking at paragraph 17, we now discuss the claimant's goodwill. And this continues for several pages through to page 71 and paragraph 24. Now, with respect to this, the factual allegations are put in issue, and also consequences of those facts have been put in issue. So if we turn to page 70 and look at paragraph 22 onwards, it's denied that there's any relevant protectable goodwill. And turning the page to paragraph 24, it's denied that the goodwill extends throughout the UK. We then come to the matters complained of on page 71 of the particulars of claim. And while some of these matters are admitted, there are denials with respect to the consequences of some of these acts. So, for example, in paragraph 29, where the allegation relates to the two domain names that were registered by the defendants, it's alleged that this was done in order to redirect traffic from the claimant's website to the infringing website. So that is denied. So the issue of intent has been denied. Moving on to the defendant's allegedly infringing activities. These commence paragraph 33, page 72. And on paragraph 34, there's a whole load of examples that are given. And with respect to the use in those cases of the claimant's mark, what is basically put forward by way of defence is that the use was de minimis and that it's been stopped in any event, but furthermore, that such use would not infringe. There's, turning the page, some allegations about pre-action correspondence, but then turning the page again to page 75, we're now on the alleged causes of action. And here, under trademarks, you can see there are 3 causes of action. Section 10.1, 10.2, and turning the page 10.3. And with respect to the 10.1, I've already mentioned that it's basically denied with respect to the consequences of the use, if any, has been made. With respect to 10.2, that's all denied. And then with respect to 10.3, which is under paragraph 42.3, again, that's denied. But if we go down and look at the way in which the section 10.2 has been elaborated, this is dealt with in paragraph 43. The long and short here is, again, it's denied that there's any similarity with respect to the marks, and in particular conceptual. There's also an issue that the patch part of the mark doesn't give rise to the existence of the likelihood of confusion in any meaningful way. Paragraph 44 makes the allegation, or provides details of the allegation with respect to section 10.3. And here again there's denials, but if you turn the page, paragraph 44.2 deals with one of the particular heads of damage under section 10.3, which is namely that it would dilute or otherwise harm the claimant's mark. And then in 44.3, this is elaborated in a slightly novel way. The claimant's ability to expand and invest in the claimant's mark will be hampered. The response by the defendants to that is that they don't understand what that's going to, which indicates, in my submission, that there's some complexity there with respect to the law, whether or not that even could be a good complaint. And then very briefly, while we're on page 77, you've got the allegation of passing off. And the long and short of all this is it's denied. Now, when this came before the judge for the CMC, as you'd expect, there was a list of issues produced by each side. And you'll find those in the supplementary bundle. And the claimant's list of issues may be found behind tab 1. And you can see it starts off with joint tortfeasorship, and then deals with the trademark infringement matters 10.1, 10.2, 10.3. Passing off deals with both the goodwill and the misrepresentation, but also touches upon whether or not there's any damage that has flown from the alleged wrong. And then point 9 of the claimant's list of issues is whether or not the claimant is entitled to the remedies, including an award for aggravated damages set out in the particular claim. The defendant's list of issues may be found behind tab 3. Now, there were 9 for the claimant, and there's only 8 for the defendant. But actually, they pretty much marry up. They're just in slightly different wording and a slightly different order. So you can see there's still 4 issues with respect to trademark infringement. With respect to passing off, instead of 3, there's 2, but that's because, in essence, the damages point has been shifted to paragraph 7 under 7b, which is loss and damage. So it's just
there's one obvious mismatch between the 2 lists, which is that defendants list, for reasons that are utterly mysterious, doesn't include the claim under section 10.1.
Yes. Yes.
Another mystery is why neither list includes validity.
Well, that I can answer, I would say. I mean, I wasn't, as you know, I didn't appear at first instance, but it seems to me that the answer to that question, my lord, is because there's no counterclaim for validity. The issue of validity, in essence, is subsumed within the question under section 10.2, or even 10.1, but most likely under 10.2, on how distinctive the mark is. Because in the defence at paragraph 16, it says the mark's not distinctive at all and therefore is liable to be declared invalid under section 3.1c. But if they lose on that, and it is distinctive to some extent, then that feeds into the analysis of the existence of the likelihood of confusion. My lord.
Okay.
Sorry, you were...
No.
Sorry. No. I was looking at paragraph 7 of the defendant's list of issues, of which there are 3. And it's actually 7A, which is an extra one. And that puts in issue the issue of whether or not the activities still continue. I've already mentioned there was an issue about whether or not the use had stopped or not. And paragraph 8 of the defendant's list of issues is the joint tortfeasorship point. Now, the defence has admitted, in essence, some of the points with respect to joint tortfeasorship. But what you can see from the list of issues that the defendant has put forward is that, in essence, the consequences of what has been known are still in issue. And that all turns on the point that the Supreme Court handed down a decision last year in Lifestyle Equities and Ahmed, where the law, shall we say, appears to have changed with respect to what is necessary to establish joint tortfeasorship in an IP case, or actually more generally even. And historically, you needed to show things like the alleged joint tortfeasor with control in mind. But now it appears that you need to go further than that, and that's why the defendant has put in paragraph 8 that if the first defendant is liable for any tortious act, or the second defendant has knowledge of the essential features of the relevant tort to justify imposing joint liability. So it goes further than what was thought before. The reason that is relevant is that it means, therefore, the joint tortfeasorship is still in issue, and it's in issue with respect to a matter that relates to the knowledge of the second defendant, and therefore that is a likely issue that needs to be examined in cross-examination of the sworn testimony. Because it is possible in the SCT to conduct a case without sworn testimony, and without any cross-examination even, which would of course be appropriate in the simplest of cases. Now, we would say, just on a cursory journey through the particular claim, that manifestly this is a case not of the least complexity, either factually or legally, and clearly would require more than one day when you're trying to consider liability, quantum, and taking into account pre-reading. It would also require cross-examination, in particular with respect to intent, with respect to the joint liability point, and that is also relevant for section 10.3 of the Trademarks Act and for passing off. You don't need a guilty intent to commit trademark infringement, but the point being is that if there is a guilty intent, it helps the claimant's case. Now, going to the judgment, we can see how the judge dealt with the issue of complexity. So I'm now back in the core bundle behind tab 5. And it starts off at paragraph 16. Turning to the complexity of the case, validity is not in issue. I have trouble with that statement. Validity is not in issue to the extent that there is no formal counterclaim. But in paragraph 16 of the defence, the validity of the mark is put in issue on an evidential basis.
Well, it's more than an evidential basis. We need to look at it. So it's tab 7, page 262, paragraph 16. Claimant's mark consists exclusive signs and indications that they serve in trade to designate the kind intended purpose, i.e. it's descriptive, not in fact acquired a distinctive character, accordingly liable to be declared invalid, registered in breach of section 31C. That seems to me to be a straight up and down plea of invalidity. Now, you're right, there's no counterclaim, which is bizarre, but you don't have to counterclaim. It's sufficient to rely upon the plea by way of defence.
Yes. My Lord, I was going to slightly unwrap that, in the sense that I was going to say that strictly there's no counterclaim, so strictly there is no application for a declaration of invalidity, which arguably would be outside of the remit of the SCT to grant. But against me, if you sort of sweep that all to one side, I would still say that this is clearly putting the validity of the mark in issue on an evidential basis. That
I don't understand what you mean by evidential basis.
Well,
I just don't understand the concept.
Well, the point being is...
It's a legal objection.
Yes, it's a legal objection, but they're not seeking the relevant relief.
So what? You can't infringe an invalid right.
Yes.
So it's a defence.
Yes. And so it's been raised in that way. Maybe I'm being overcautious because I was actually taking a point that my learned friend could take, that there's no formal counterclaim.
If they accept that the trademark is valid and delete this paragraph from their defence, then the issue would disappear.
Yeah.
But if it doesn't, if it stays, then it's plainly an issue.
Well, in which case that's a point in my favour. And
yes,
even if the mark is valid, what is still in issue, indisputably, is how distinctive is the mark, because that feeds into the analysis of the existence of the likelihood of confusion. If the mark is of low distinctive character, it's more difficult to infringe it. So there's still a big evidential point there. That's the minimum irreducible point that's in contention.
yeah.
Moving to the second sentence. There may be a little more to the case than summarised by the defendants in the section 10.3.
Right, we're back on page 57 now.
I'm terribly sorry, my lord, yes. I was back into the judgment.
Thank you.
Core bundle, tab 5, page 57, paragraph 16, second sentence. The judge is moving on to section 10.3 of the Trademarks Act, can sometimes raise issues. In my submission, that statement is open to question because it omits any acknowledgement or awareness of the complexities of the case that has been raised here. Because that rather suggests that this might be a simple 10.3 case. But actually, this case raises pretty much everything to do with 10.3. Whether or not an unfair advantage has been taken, whether or not there's any intention with respect to a taking of unfair advantage. There's a dilution argument, which is always tricky. And I drew your attention to the other harm argument in paragraph 44.3 of the particulars of claim about the inability to invest and so forth. That's a potentially new argument, as already indicated by the fact that defendants don't understand it fully. For section 10.3, it's essential to show that the mark in question had a reputation at the relevant time. That's all being put in issue. And there's also a pleading in the defence that it is denied that the similarity of the goods is relevant to the question under section 10.3. Well, that's wrong as a matter of law, but it shows that there's another legal point there. And so, in my submission, this one sentence by the judge dealing with section 10.3 is wrong because it clearly indicates he has failed to appreciate the complexities of 10.3 in this case. He has just dismissed the 10.3 case as, in essence, being simple, where it's plainly not on the pleadings. He then deals with section 10.2. I agree that section 10.2 is likely to be largely about the likelihood of confusion, which need not require a great deal in way of evidence and argument. But, as we've already seen, there's clearly an issue about how distinctive the mark is. This feeds back into the first point about validity. But assuming that the mark is sufficiently distinctive to be valid, it's still a question of fact as to how distinctive it is, because that will feed into the question of the existence of the likelihood of confusion. And then there's going to be questions about whether or not the trademark and the allegedly infringing sign have sufficient commonality conceptually, orally, or visually, such that there exists a likelihood of confusion. Moving to section 10.1 applies to the first defendant's use of piddle patch, but that seems to me to be a short point. There may be a dispute about when the first defendant stopped using piddle patch. This goes to quantum rather than liability. That statement is wrong because in the SCT you need to determine both liability and quantum. And the way in which the defendant has argued the section 10.1 point is that the use was de minimis and therefore no damage arose. But you still need to determine whether, if there was any use, whether that use infringed. And this raises a question of comparative advertising under the business protection from misleading.
Why, when that defence isn't relied on?
Well, it is mentioned in the defence expressly, my lord.
Is it? Where's that?
Paragraph 32.2, the defence.
Page.
I'll just get that for you.
Thank you.
269.
Thank you very much.
Thank you. So this is the defence, paragraph 32.2.
All right, I hadn't seen that. Okay, thank you.
The point here is that section 10.1, the wording of the provision is that if you have identical sign mark and identical goods and services, then there is an infringement. But the jurisprudence has elaborated upon that somewhat in the case of L'Oreal. And what is necessary is there has to be some harm to an essential function of the trademark. And that requires an analysis of what has actually been done and whether it harms an essential function of the trademark. But there's another point, and that is you're allowed to use somebody's trademark, registered trademark, for exactly those goods and services for which the registered trademark is registered in certain circumstances to allow comparative advertising. That's only right and proper, but you can only do it if you meet certain criteria, and those are, for example, set out in the Business Protection from Misleading Marketing Regulations. And that then feeds back into the way in which trademarks are analysed and could potentially be harmed. So there's an analysis there that needs to be done. There's also a question here that whether or not the mark or the allegedly infringing signs, have been stopped in their use. That goes to intent, because it depends when they were stopped and whether they were reused again. Because if that use was recommenced, and that feeds into the overall question of intention. And so therefore, by failing to appreciate all these other things, in my submission, the judge has omitted taking into account certain things. Now, dealing with the last sentence in paragraph 16, it is frequently the case in the small claims track that quantum is dealt with at the same time as liability. That is a matter that the small claims track judge can resolve. Yes, but of course it goes to the amount of time that needs to be allocated to the case. But there's no consideration here by the judge of the alleged wrong of passing off, so that's an omission. There's no mention here by the judge of the issue of joint tortfeasorship, which both parties identified in their list of issues, so that's an omission. There's no issue here or indication here of anything to do with the quantum questions of flagrancy, additional damages and convoyed goods, so that's an omission. Those go to not the value of the case in this part of the argument, but go to the complexity of the case. Now, the judge then continues, paragraph 17. I also note that the claimant did not list any factual dispute in its draft list of issues for a prospective CMC in this court. I don't fully understand that statement.
Well, it seems to be completely wrong when you look at e.g. paragraph 6, whether the claimant owns substantial goodwill in the UK, which, as is well established, is a factual question.
Yes, my lord. I was trying to put it more neutrally, shall we say, because it is correct that there were no list of issues of a factual nature that would arise at the CMC to be disposed of. But that would be irrelevant to the complexity of the case itself. But otherwise, it's wrong with respect to the list of issues that were filed. So, in my submission with respect to paragraph 16, he has clearly admitted to take into consideration a large number of relevant matters with respect to his consideration of the complexity of the case. And because he failed to take into account those relevant matters, in my submission, he plainly reached the wrong conclusion. And that's just with respect to the factor of complexity. My lords, I was then going to deal with how the judge dealt with the value of the case, because that's another indicator. This starts off on the previous page of the judgment, paragraph 7. And what's relevant to note here is that it's accepted that there were about 11,800 products sold by the first defendant, and that the total turnover figure was about 3,900,000. Now, those figures need to be treated with a little bit of caution, because it is fairly clear from the evidence that there were other goods apart from the allegedly infringing goods But it is also fairly clear that both these companies, the claimant and the first defendant, in essence had one product and a number of associated products. And so therefore, with respect to the financial issue, there's going to be a question of whether, if you sell an allegedly infringing item, and that automatically or invariably leads to the sale of a non-infringing item, can you also claim damages for what's called the convoyed goods? Now in paragraph 10, the judge says, in the second sentence, however, no sales or profit figures are provided by the claimant. Now, in my submission, it is irrelevant what the sales figures of the claimant are, unless you're going to run an argument that the claimant was in such a weak position that it could not have taken up any slack by the defendant, i.e. could not have made those sales that the defendant made because it didn't have the capacity to make those extra sales. But that's not indicated, and so therefore prima facie it seems to be an irrelevant thing to take into consideration. And then in paragraph 15 you get to the core of the way...
I don't understand that.
Sorry.
The point he's making is that if you assess damages on the basis of lost sales and therefore lost profits, you're going to need historical figures. And despite being challenged to provide historical figures, your client was not forthcoming.
But my lord, the point being is in an inquiry as to damages, one of the ways in which you can assess the loss and damage suffered by the claimant is that you make the assumption that for each sale the defendant has made, that is a lost sale to the claimant.
But why would you make that assumption in a trademark case?
Well,
it's not a patent claim.
no, I accept that. But that actually then just raises another issue of law. Because actually the Blaney case, which is a copyright case, expressly refers back to patent cases and says that there should be no difference between copyright cases and patent cases, but doesn't actually talk about trademark cases.
I don't understand.
Sorry.
If the question is the legal question of whether you can have damages assessed as a reasonable royalty, we know that the answer to that is yes, because it's been done.
Yes.
You don't cite the case, but
Yeah.
it's quite well known. It's the 32 Rid case.
Yes.
So, and Mr. Saunders has, in his skeleton argument, hasn't taken issue with the legal question of whether you can assess damages on a reasonable royalty. But that's a different question. We're talking, in the first instance, about damages assessed as lost profits. And you asserted that if you were looking at lost profits, you didn't need to know about the claimant's sales because you could simply assume that every sale made by the defendant was a sale lost to the claimant. And I was questioning that assumption.
Because the way in which the judge put it was, however, no sales or profit figures were put forward. I wasn't challenging the profit point. What I was talking about, in essence, was the volume of sales figures. So it's irrelevant to consider the volume of sales of the claimant. It might be relevant to consider the profit margin of any sales that were made. But whether the claimant made 10 sales or 100,000 sales, that in of itself is irrelevant unless you're going to argue, when you're trying to do this analysis, that the claimant can...
All right, but surely the point the judge is making is a perfectly straightforward one, which is you haven't put forward any financial information at all from which a profit margin could be derived.
Yes.
I mean, normally, if you're working out the profit margin, item 1 in the calculation is how many sales you've made.
Yes, but it is but it's actually irrelevant. You don't need to put forward how many sales you make. You only need to say that on any sale, the profit margin would have been X. That's why I divided this phrase. I passed it between sales and profit. I wasn't arguing about the profit part.
You might get away with that very clever distinction, but factually you need to show the sales. And all the judge said is that you hadn't given us that.
My lord, it was only a short point, and it's now. But yes.
Well, help me with this, Mr. Edinburgh. This is a judge at a CMC
Yes.
considering the allocation of a case to the appropriate level of hearing. Is the judge in that position entitled to use his experience to listen to the innumerable points ventilated on each side, but to form a view as to the reality of the case?
Well, my lord.
In other words, is the judge bound? If you say there are 27 issues and therefore it's far too complex, is the judge bound to say, oh, all right, then there are 27 issues and therefore it's very complex? Or can he say, yes, but in reality, this is two one-woman companies dealing with one product and to a very modest extent some associated products. The defendant says the whole thing can't be worth anywhere near £10,000 and the claimant hasn't put forward anything to suggest otherwise. So really my question is, I'd be very grateful for your help, is the judge simply bound to accept, because the parties say, oh, there are all these issues, that there really are all those issues and the court's time must be set aside to deal with them, even if in reality he thinks there isn't a huge amount in this?
Well, my lord, directly answering your question, no, the judge is not bound by the submissions of the parties either way. And the judge must exercise his discretion. He must be free to exercise his discretion as he sees fit in a way that's appropriate to the case before him. But, and this is where I would put my case, is that on the plain face of this case, the parties have joined issue on everything. It's not a case where the claimant has said there's 1,001 issues, and the defendant has said, I concede 999 of them, so there's only 2 left. It's quite the opposite here. The claimant has put forward a whole load of issues, and the defendant has joined issue with each and every one, and in some cases made it even more complicated. For example, the section 10.1 point, by raising the comparative advertising points. And that's the reality of the case. The judge is faced here with 2 parties at loggerheads. It's unlike, in my submission, a case where a photographer has taken a photograph, it's clear that he took the photograph, and it has been reproduced in toto on a website by somebody else. And there it is absolutely clear that the real issue is how much should the website owner pay. There's no issue there of whether there's copyright in the photograph, there's no issue of who owns it, no real issue. And no issue of infringement, whether the whole or a substantial part have been taken. And the other example that was given with respect to an author and an article, the author wrote the article, copyright subsists in the literary work, and whether or not it's been reproduced, you can just see whether it's been reproduced or not. The question is the money side. Should they pay 100 quid or 250 quid or £1,000? That's the issue. And even if the parties are at loggerheads, the judge can say, look, you're not really putting in an issue that the author was an English citizen and therefore qualifies.
Okay, thank you.
My lord. What I was going to move on to was the way in which he sort of summarised this, which was in paragraph 15. And this picks up on the point that my lord has just made about the very little evidence that's there. The point here is that he's basically focusing upon the relevant profit made by both the claimant and the first defendant. But in my submission, this fails to take into account that another way in which you could assess the financial compensation to the claimant is on a straightforward royalty basis that my Lord Justice Arnold has already mentioned.
Yes, but respondents say that that wasn't raised before the judge and therefore he can't be blamed for not taking it into account.
Well, in my submission, actually, he can be blamed for not taking it into account because he had the relevant data in front of him. And I showed you that in paragraph 7, where he knew that it was not disputed, that there were 11,800 relevant items that were in contention. And we know that the turnover was about...
I don't understand that. Yes, of course, there's data in the case. But the question is, he's being asked on transfer application to form a view as to the value of the claim. And why is he to be criticised for not taking into account a potential valuation based on a reasonable royalty if no argument to that effect is put before him?
Because he's a very experienced judge who has a lot of experience in this area and therefore is perfectly familiar with the fact that if you have 11,000 odd sales, a perfectly reasonable argument would be you have a royalty rate based on it, either per item or a percentage.
So the argument is he should have taken the point of his own motion.
Yes. This is not some judge who's new to the IP world. You can see from the turnover figures that the items sell for broadly 30 odd pounds on average. And if you just put a royalty rate of £1 per item, so as opposed to a percentage, you put a per item rate, you get to £11,800. That would work out at about 3%. And being a very experienced judge, you'll know that's not unreasonable. In the Blaney case, which was not before him, the royalty rate was 5%. So I'm not...
Copyright claim in a very different...
No, so, no, I was going to say that I'm not criticising that he didn't take the 5% in his mind, because the Blaney case was not put before him. But what he has also failed conspicuously to take into account is the issue of additional damages. Now, there is an argument that he did that correctly because additional damages arguably cannot be awarded in addition to a profit, but they can be awarded in addition to an acquirer's damages.
Yes, well, your client's pleading is perfectly clear in that respect. It's very clear that additional damages are claimed in the event of damages being claimed rather than profits.
Yeah, yeah. That's the Carla Holmes case.
Yeah.
And the point about the additional damages, it all goes in essence to the behaviour of the defendant. And that all feeds back into these factual issues.
But how is he supposed to take a view on quantum of additional damage?
Well, that's the point being is you can't, it's very difficult to take a view on it because it's dependent upon the evidence. And that feeds back, and that's why I raised it primarily in the complexity context. But it is something that he's admitted to even mention when he's dealing with the financial side. He could have mentioned it and said, there is the issue of flagrancy, but for the following reasons, in my view, it's not going to amount to much. My lords, that's all I wanted to say on that, because I've still got a second point, but I'm going to try and take that much quicker if I can. My lords, is there any more on that?
No.
Right. Because by way of summary, therefore, I say he admitted relevant things, and therefore, both on the complexity of the issue and the value of the issue, therefore was wrong. Therefore, you can interfere. My second ground, I have to satisfy you that I'm allowed to raise this point because it wasn't raised below. I was going to deal with the whole matter very briefly because otherwise my learned friend doesn't have enough time to respond. But the issues whether or not I can raise it on appeal are set out in Rhine Shipping. And for your note, it's paragraph 23, and it's Authorities Bundle, tab 4, page 88. If the Benny essay, you will allow me to open this case on that, because otherwise I'm going to have to go through that.
Well, you say it's a pure point of law.
Yes, exactly, and we say there's no facts and all the other things. I've set it out in detail in my skeleton at paragraph 21, which is Core Bundle, tab 2, page 24.
Why wasn't this raised below? Even in shorthand form?
My lord, I can't answer that question. I don't know. Neither I nor my learned junior, my present learned junior, appeared below.
I understand that, but you could ask.
Well,
The point's been taken against you.
we did and didn't get any satisfactory answer. There's a problem with respect to the junior who was below, my lord. I don't wish, if I may, to go further on that.
All right. Okay.
All I can say, it ought to have been taken, it ought to have been reserved. It was not taken and it was not reserved. So to that extent, we have to throw ourselves upon the indulgence of the court. But I can't give you a fuller explanation for reasons that I'm not really at liberty to give. Right. This all starts off with the Directive 2004-48 EC. Is Article 14, which allows for the provision of costs in such cases. That's the Authorities Bundle, tab 9, page 224. Member States shall ensure that reasonable and proportionate legal costs and other expenses incurred by the successful party shall, as a general rule, be borne by the unsuccessful party unless equity does not allow this. This directive, the enforcement directive, was incorporated into UK law, and there's an explanatory memorandum which you'll find behind tab 14. And the relevant bit for our purposes may be found on page 325. Where it says, no specific implementation is required as this rule reflects the general practice before the English, Scottish and Northern Irish courts. So therefore, on that basis, it may be assumed that the UK, England and Wales in particular, practice was in accordance with what was intended by the directive. We then come to the United Video case, and you'll find...
But as a matter of chronology, we need to know that was before the reforms to the Patents County Court to transfer it into IPEC, and therefore R40 all the way before the creation of the small claims track.
Yes, yes. You see all that from the date of the explanatory memorandums, 2006, page 212. And if you go to tab 15, the explanatory memorandum for the small claims track is 2012. Going to the United Video case, which is behind tab 7. this issue is dealt with on paragraphs 20 through to 32, which start at page 196. But for present purposes, the most important paragraphs are 26 and 32. '26 basically says that a flat rate scheme imposing rates significantly below the average rate cannot be justified, and that's reiterated in 32, which is the paragraph that forms the basis for the dispositif. Now, in the IPEC SCT, which you'll find behind the guide, for which you'll find behind tab 12, the cost provisions are set out on page 274. And the long and short of it is you broadly don't get attorney's costs. Now that's not a problem if there's no attorneys, or if they're acting pro bono, or if some other way they've waived their entitlement to the fee. So there's no, in essence, bar to being represented by attorneys. But it does sort of suggest that this is a sort of forum for those cases where the cases are appropriate to be conducted without the assistance of attorneys. So therefore you don't really want to clog up the SCT with systems, with cases where there are attorneys and they can be afforded. Going to Tumblr. This is behind tab 2 of the authorities bundle. And the relevant bit for present purposes is paragraph 30 to 31 page, which is also on page 30. In my submission, if you read the way in which the judge has analysed the matter in paragraphs 30 and 31, he has misunderstood what was said in the dispositif in the United Video case. And that he is saying, in this case, the judge, that if it has been decided it is appropriate not to award costs in certain matters, then that's fine and is permitted by Article 14 of the Enforcement Directive. But in my submission, the way in which the dispositif in United Video should be read is that it's rather assumed that costs will be awarded, and the question is whether or not appropriate costs will be awarded. And so the consideration of appropriateness comes in at a different stage. And in the judgment, the judge at paragraph 20 said, the fact that both sides have legal representation is not, to my mind, a factor. If I'm right on the analysis of United Video, then it ought to have been a factor, because in the SCT, it would not be possible for those attorneys to get an appropriate award of costs. And therefore that analysis is wrong because he failed to take into account a relevant factor. My lords, I've dealt with that as quickly as I can.
Well, you haven't dealt with the two main points against you, which are 1, no direct effect, and 2, ruler.
The no direct effect point is that the way in which the UK costs scheme ought to be understood is in compliance with the way in which the EU directive suggests on an ongoing basis.
Right? I mean, the whole point of Brexit was so that we didn't have to continue looking over our shoulder.
But this was all just, the ongoing basis is that up until the 31st of December 2020, and these cases inform the way in which you should understand the regime before then.
But this provision hadn't been implemented into national law because IPEC hadn't been thought of at the time it was imposed or transposed. And therefore, fine, there was an error. We might have been infringing EU law and directives at the time, but come 31st December 2020, then it's too late.
But the way in which I'm putting it forward, I don't really want to spend too much time on this, my lord.
Well, don't rush this point.
No, is that if there had been an obvious mismatch between the way in which the enforcement directive suggested that costs should be allocated and when the SET scheme was put forward, if it were thought that that would create a mismatch, then something ought to be done. But as nothing was done, I'm working on the proposition that it was thought that the SET scheme was not in conflict with the way in which
But your case has to be that it is. Because the essence of your case on ground 2 is that it is contrary to Article 14 to have no cost shifting. And the whole point about the SCT is that it is in essence a no cost shifting regime.
No, I endeavour to try and turn the argument on its head, my lord, by saying that actually you assume that the way in which the SCT is going to be implemented will be in accordance with Article 14. And as a consequence, therefore, it's not appropriate for cases where there's going to be attorneys seeking their costs. That's as far as I can put that argument.
But can I just understand, please, the consequences of that argument? Because you've spoken about the scheme, that the small claims track being suitable for cases where neither party has attorneys. And you've spoken about the position of both parties having attorneys. But speaking for myself, it seems to me the consequence of your submission is that any defendant faced with a claim that might be allocated to the small claims track can simply say, I want to be represented by an attorney. And on your argument, the judge will be bound to say, well, it's not suitable for the small claims track.
No, my lord.
And how does that work in terms of deterring
Because
litigants?
the way in which it would work is there's no bar to being represented. The bar is for those attorneys then to seek their costs on an appropriate and reasonable scale.
Yes, I understand that. But if you take the sort of example that you've referred us to from the guide, the photographer who says his proprietary interest has been infringed, along comes the magazine publisher, represented by leading and junior counsel, putting in a large bill of costs even for the CMC, and says, well, this is a case in which our side want to be represented by attorneys, and therefore there has to be scope for us to get some costs if we win.
But my lord, the reasonableness or otherwise of being represented by leading and junior counsel, if there's only an issue of quantum.
All right, take the leader out of it.
Even so, if it's only...
What the judge might say,
well,
you're entitled to be represented, but it wasn't reasonable for you to be represented.
well not reasonable for them to recover the costs. But the point being is that it goes to then back to the complication point. Is it really actually an issue that is sufficiently complicated that justifies having legal representation?
All right.
If you're going, sorry.
Mr. I'm sorry. I need to understand the legal basis for your argument. So let's take it in stages. 1. Do you say Article 14 has horizontal direct effect?
No.
2. Do you say it has vertical direct effect?
Vertical effect, yes.
Okay. And is that, let's assume the moment that it does have vertical direct effect. How is that relevant?
It's only relevant, and this is the way in which I put the argument, is if it has direct effect, then the way in which the UK government has said that it has direct effect is that it's because its effect is already put into effect by the way in which the cost regime works in the United Kingdom. There was no need to expressly do anything.
I don't understand that, because let it be assumed, all we know is that at the stage when the enforcement directive was implemented, the issue didn't arise because the small claims track in the IPEC didn't exist. At that time, your only options for litigating an intellectual property claim were the High Court or the Patents County Court, and the cost rules in the Patents County Court were essentially the same as in the High Court at that day. And hence we see the statement in the table, because there was no question of an IP claim being litigated in a no-cost shifting forum. That only arose subsequent. Now, so far as one can tell from the available materials, there was no consideration of Article 14 when the small claims track was instituted. That appears to have been an oversight. So you can't point to anything that says when the small claims track was implemented, that says we think this complies with Article 14, can you?
No, I can't.
Right.
So the only way in which I can run the argument is by saying that those people who were responsible for the creation of the SCT did take into consideration the enforcement directive and still thought there was no need.
No, you've just accepted there's nothing to show that it was considered at all.
But I can argue, though, that you can implement the SCT in a way that is compatible with the way in which the case law has developed for Article 14.
All right, but that, as I understand it, is an argument based on Marleasing, yes?
Yes.
Right, so I think where we've got to is your argument is that the SCT regime in IPEC should be interpreted consistently with Article 14 based on Marleasing.
Yes, that's as far as I can run it.
Right, so that leads on to the next point that's taken against you, which is you can't rely on Marleasing because of ruler.
Well, I would say you can to this limited extent, in that the case law that gave rise to this issue is 2016. So that's United Video. And so therefore, the way in which the UK should understand the cost regime of the SCT of 2016 would be in compliance with Article 14. And there's nothing that's changed that. That then becomes assimilated law.
I don't understand it, because this claim was commenced in 2024.
Yes, yes.
After ruler comes into force. And the issue of allocation is decided in October 2024. And at that point, ruler tells us that Marleasing can no longer be relied on.
But the point being is that therefore you're going to have a period between 2016 and 2020 where the SCT regime is understood in compliance with the way in which Article 14 is understood. And then the law magically changes because of ruler.
Well, that was the point of ruler, wasn't it? It
Well,
was to change the law.
But no, it wasn't to change things. It was to allow for changes. Things are not, you're no longer bound by things that are happening now. The things that had already happened.
And what about the position before the 2020, after 2016? Had this point ever been taken in the SCT?
As far as I'm aware, no. But I have not done an exhaustive search. And also there's a problem with fact. I don't think those cases are commonly reported. So, as far as I can go is no. But I can't say that's a definitive answer.
And you answered to my lord the question that there was vertical effect. So are you going to take us through the relevant article to show why it's sufficiently clear to have direct vertical effect?
Well, I simply say that on its wording, it is directly.
What
Sorry.
about the qualifying words then?
Yes.
Which are save to the extent of equity?
Yeah, exactly.
Because
All right, but before we go into that question, I thought I understood you to accept that vertical direct effect wouldn't help you, even if that was the case. Did I misunderstand?
No, I mean, I don't need to. In my argument, I don't need to rely upon it. But if I am going to address that point, I mean, I say it's basically the same as the.
All right, but this is why I need to be clear as to the basis of the argument. Because if it's a Marleasing argument, you don't need vertical direct effect.
Yeah.
So which is it?
Well, I rely, in essence, upon the Marleasing point. Now, let me just sweep away the vertical, even though I do think that it does have
Yes,
vertical
but
effect. But let's put that to one side.
as you, I'm sure, are fully alive to, vertical direct effect involves two questions. Firstly, is it directly effective? But secondly, is it relevant? Because normally it's only relevant if your claim is against the state.
Yes, and my claim's not against the state.
Right.
I mean, I do say it's directly effective, but I don't. That's not my argument here.
Your argument is Marleasing.
Yeah. But just to very in one line deal with my Lord Ingham's point. If you look at the wording of Article 14,
Yep.
and if you look at the wording of Articles 5 that are raised in the referral case, they're very similar. And that's how I'd argue it.
Thank you.
And that's probably sufficient time on that point, if I may, my Lord.
Well, if you are really relying on the interpreted point from Marleasing, then yes.
Yeah.
Yeah. Okay.
Goes
Thank
to
you.
one side. It wasn't a hopeless argument, just not necessarily a strong argument.
Not here to comment on that.
No. But I really wanted to spend a lot less time on that point. But
Even though it was the main basis upon which you got permission to appeal. Yes, all right.
depends how one reads your permission, my lord. He says, if I may be allowed to squirm a bit. My lords,
All right, so be it.
my ground one is the principal ground. Basically, a whole lot of relevant things were just simply not taken into consideration. That vitiates the decision. Simple. And if you look at all the indicators, they all point in one direction, which is away from SCT. That's my principal argument. My lords.
No, thank you very much indeed. Oh, messages coming.
Yes.
Yes, Mr. Saunders.
My lords, if I may, I'll take the points in the same order that my learned friend did, if that's the persistence, or I can do them back to front, whichever assists. Now, stepping back from all of this is perhaps an abject lesson in why two leading counsel shouldn't be let anywhere near small claims tract cases, perhaps. But let me address the issues in the end. This was, on any view, a case management decision by a judge of unrivaled experience. He is the designated IPEC judge. He spends a lot of his time deciding questions of quantum, in fact, has rather more experience doing that than almost anybody else in His Majesty's judiciary, because these issues come up a lot more in the IPEC than they do in the High Court, because often after liability is established in the High Court, damages questions settle. So he is very familiar with that, and he is, in my submission, perfectly entitled to form a view about the case. Now, he is entitled to do that not only as a result of his position and experience, but also the fact that the claimant was asked a number of times to substantiate their claim that this was a very substantially high value case above £10,000, and failed to do so, a point which my lords have already observed. It is not, my learned friend said, well, he should have taken a point of his own motion on quantum, but that is, in my submission, an unfair criticism of the judge, where he's had professional representation on both sides before him, and it's reasonable for him to take the view that if there had been anything relevant, that would have been drawn to his attention. But stepping back from all of this, part of the rationale for the small claims mechanisms, which we've seen, my lords have already been taken to some of the explanatory materials, part of that is also dealing with points arising from the overriding objective, because the cases are to be dealt with in a way which is proportionate to the amount of money involved, and the importance of the case more generally than to just the parties, the complexity of the issues, and dealt with expeditiously and fairly, and allocating to it an appropriate share of the court's resources, while taking into account the need to allot resources to other cases. Now, we've seen a lot of cases with prolix pleadings, but again, it is, I would submit, perfectly proper and appropriate for a highly experienced judge making a case management decision to take a view on those, as my learned friend accepted, and as part of that to make a decision about track allocation on his view of what really is an issue. And I'll come back to the significance of the list of issues, because in the IPEC they have a rather more significance than litigation generally. My learned friend took you to Jalla and Shell. There's very little between us on the principles there. The only other point we draw to your attention in Lord Justice Coulson's judgment is that it's vital for the Court of Appeal to uphold robust, fair case management decisions by first instance judges. And that is so even if the consequence of the decision has a very significant impact on the proceedings. Jalla itself was quite a striking example of that. The effect of Mrs. Justice O'Farrell's decision there was to chop 28,000 claimants down to 9. So it's difficult to perceive of a more extreme, perhaps, case management decision being taken, but it is not, in my submission, for the court to interfere unless there is a clear error of principle in the way that the judge has approached the assessment of the matters before him. Now, my learned friend made a point that a number of points about the background to the introduction of the small claims track. I don't think there's very little between us on that, save for his submission, which I think he's slightly backed away from in oral submissions, which was that the policy objective behind the introduction was clear. He says it's to particularly concern with people with limited means. That we submit is not an appropriate gloss on what you see. It was to improve access to justice for those with small or low value claims. But critically, those benefits, the access to justice benefits, work both ways. If there's a benefit to potential claimants, because a claimant can run a claim without being worried about the consequences of an adverse cost order, and you could easily see in a case like this how that could become oppressive. Just to give you two figures that were relevant below. The other side were asking for almost 13,000 on the transfer application alone, for their costs on that. And the partner, the claimant solicitors, is charging £900 an hour on this case.
1100 now.
But you get possibly.
It's gone up according to the schedule.
Oh well, there we are. Now, I mean, obviously that's a question for the judge to assess, but you can easily see how those kind of costs could have a highly oppressive effect on and potentially stifle what could otherwise be a good case. I mean, it would be a brave person that wants to put their house on the line to bring that kind of litigation. So the benefits are identified in the legislative materials from the perspective of the potential claimant, but they also have a flip side, which is that the same benefits come to defendants who need not incur costs to defend a low-value claim, or need not run a recoverable costs risk against them to defend a low-value claim, and this risk of claimant's costs being out of proportion to the value of what is in issue. And what is very striking about this case, when you look at the materials below, is, as I mentioned a moment ago, that the value, there was no real submission that the value was anywhere north of £10,000. They were put on notice at this point a number of times, and as the judge rightly observed in the judgment, didn't make that case good. So this becomes litigation about costs. And that is not, in my submission, germane to that is not germane to the issues in the case or the complexity of the issues. And it's entirely appropriate for a highly experienced judge like His Honour Judge Hacon to take a view against that background. Now, the case itself, my learned friend took you to a number of aspects of the pleading. There are a large number of complexities in trademark law. That is a point I needn't lecture Lord Justice Arnold about, I'm sure. It is easy to identify in any case some nuanced points, and that is what my learned friend did to a certain extent in his submissions.
Well, I'm not sure the challenge to the validity of a trademark is in any way nuanced.
Well, my lord, if I may, I'll come on to that in a second, because that isn't in the list of issues, and that's terminal for the point.
Why?
Because in the IPEC, it's the list of issues that govern the issues for trial.
So, can we take it, therefore, that contention is abandoned?
Yes.
Right.
So it's like the employment tribunals in that respect.
The list of issues are the funnel through which evidence is ordered by issue and everything else. It's a device. So it's not the commercial court list of issues where one spends weeks and weeks debating the list of issues and then run something completely different at trial. This is it's as it were the funnel through which the case is then.
It shouldn't happen in the commercial court either.
No, my lord, sorry, I didn't mean to suggest that, but sometimes these things develop a life of their own. So, stepping back from this case, the claimant is a small business, the defendant is a small business. They are both essentially one-woman companies. The claimant has a UK registered trademark for the sign Fiddle Patch. The defendant, the first defendant, has admitted use of that sign for a period of time. That is not in issue because it has been admitted. Hence, there is no 10.1 issue to be determined at trial. As the judge rightly observed, there's a question about the extent of damage that's attributable.
Sorry, I again need to be clear, because on the defence, there are a number of issues raised in relation to 10.1. Are you telling us that infringement is admitted?
All of the factual circumstances are admitted. There is no, I think the formal pleading, let me just find it for you, I think it's, it is said to have been de minimis. And the other critical thing, which my lords may have just to complete the picture, is that the defendant gave an undertaking at the hearing not to repeat the use of the sign Fiddle Patch.
Well, indeed, which limits quantum, but doesn't.
Well, it takes the issue away because there's no, the undertaking has been given, and so there's no need for the court to go on and determine whether there's a need for relief in respect of the 10.1 infringement. other
Why?
than quantum.
What about the claimed damages?
Well, my lord, yes, and that's a question of whether that is still at large.
Yes. So, as I say, it goes to quantum.
Yes, it
And
does.
obviously, it absolves the need for an injunction.
Yes,
But
no,
I'm sorry, we're getting a number of things tangled up here. So let's return to basics. In the defence, there's a whole series of issues raised on section 10.1. You're saying they're all abandoned, and you now accept that there's infringement, and the only question is quantum.
well, my lord, I think. Let me just get the. Hopefully my learned junior can just get me the references to the bits of the pleading, and I'll come back, if I may, to that. It's the defence of paragraph 24.
And for example, the point about comparative advertising that Mr. Edenbrook drew attention to, that's only relevant to the 10.1 allegation. It's not relevant, it's not relied on for the other allegations. So if it's abandoned, then we can forget about it.
Well,
if it's not abandoned, we can't.
No, but it's not included in the list of the comparative advertising is not included in the list of issues. So,
right. So you are inviting us to take your client's list of issues, even though it doesn't seem to say so, as an admission of infringement in relation to 10.1. And the only question, therefore, is quantum.
well, my lord, I'm not sure I'm in a position to give that concession.
Well,
No,
I understand
no,
that, but you see, you seem to be putting a weight on the list of issues, which at the moment I'm struggling to understand. I mean, if it were your client's position that lots of things that were raised in the defence were thereby abandoned, that would be clear. But you seem to be less clear about that.
Well, the reason for the comparative advertising point is that was originally raised by way of factual background to the way that the claim had developed. There are 4 blog posts that it's concerned with, which may or not amount to a comparison between the registered mark and the defendant's use of that mark. If that is what they believed at the time, but it is not. But it is admitted that those blogs reproduce the sign. So it goes to a question of the defendant's state of mind at the time that those signs were used. But I don't think it is formally run as a defence to the 10.1 allegation. I need to just double check that on the pleading.
But so what's the judge supposed to do? Whichever track this is in, apparently the judge is going to be required by your defence. I appreciate the list of issues may have superseded this, but let's just take the defence. Apparently, the judge is going to have to consider whether this is lawful comparative advertising or not, even though you say it's not being relied as a substantive defence. How? Can you explain to me how on earth that is proportionate?
Well, my lord, it's not. So let me just find the relevant points. I think I'll just go through the pleading slightly more detail. The reason the plea is there is because of the way that the case arose and what was said at the relevant time about the use that was complained of. Now, that use, as you would have seen in the pleading, was ceased on the 17th of January 2024, so before the claim was issued. Now, there are 4 blog posts that it concerns, and as to which there is a question of whether potentially there are damages by reason of that use.
Well, to be sure, look, Mr. Saunders, let me be clear. I'm not suggesting that your client isn't fully entitled, your clients aren't fully entitled to say, we've done nothing wrong. We believe we were in our rights in doing what we did at the time. As soon as a complaint was raised, we stopped, and it's all de minimis, and therefore there's no infringement. That's perfectly legitimate. But if that's the position, it has potential consequences in terms of complexity. Whereas, if it is your client's position, we admit infringement and we say the quantum of damages is close to zero, that's different.
Yes, my lord, the answer is there is no formal admission of infringement. The defence is paragraph 32.2 on page 269, and the point is run that this is this is 4 posts which were removed, and it is all de minimis. Now, the judge can take a view as to whether anything attaches to that.
Yeah, but of course, the 10.1 complaint is not confined to these 4 blog posts. There's other acts as well.
No, but which the judge will have to, which the court will have to take a view on in terms of damages. That use has been admitted factually.
Right, but
and an undertaking given not to repeat.
It's an infringement.
It is, well, only in respect of the 4, my lord. But, my lord, the difficulty with this exercise, I mean, these are all arguments which were not taken below, and I'm not suggesting for a moment, my lord, that they're not legitimate inquiries, but we are dealing with the question of track allocation in the IPEC, where both sides were professionally represented, and the points were not being taken in relation to complexity. Again, the question for this court, in my submission, is the question of whether there is something which should lead this court to interfere with the decision that was taken, and where it isn't a proper basis on which to criticise the judge in those circumstances, where points were not pursued before him.
I
Arnold,
of course take that point, but that's a different point, because one of the things that concerns me about this case is that whoever tries it, in whatever track, they should know what issues they're being required to decide. At the moment, it seems to me there's considerable lack of clarity as to what issues are actually going to be required decision.
Well, my lord, I don't pray this point in aid particularly, but that is, I'm afraid, a feature of justice for low-value proportionate justice in low-value cases often, where this one is very unusual because the lawyers have produced prolix pleadings and then various parts are called out. But it is often the case in the small claims track that the judge hearing that case will form a view, if anything, about what are the real issues in the case, and they'll do that often without the assistance of legal representation by the relevant parties, and will shake down in a proportionate way what the key issues are.
I don't question
the judgment.
But how does that help in this case when we've got extensive and elaborate pleadings, which on the face of it raise a series of issues which the judge in whatever track will be required to decide? Are you suggesting that they can somehow ignore the pleaded issues?
Well, my lord, the point about the list of issues, the point I was making to a moment ago, is that they are the funnel through which the issues are to be decided. Now, this is, I mean...
But I'm still... You repeat that point, but we come back to section 10.1. As I say, if we were admitted that there were infringement on 10.1 and it was just an issues to quantum, I could understand your position. But you seem to be simultaneously arguing that A, it's an issue, and B, it doesn't have to be decided. And that is where I struggle.
Oh, well, my lord, that's more a failure on my part, I suspect, than the pleadings. I can't say, as the pleadings stand, it is not formally admitted.
Right, and therefore it has to be decided even though it's not in the list of issues. Or, sorry, to be clear, it's not in your client's list of issues, but it is in the claimant's list of issues.
That's the distinction.
Right.
But that is a question which doesn't, in my submission, render this unsuitable for transfer, because the exchange that my lord and I have just had, and by the time the case comes to be decided, or to be heard, it potentially will shake down those kind of issues. We are talking about, I mean, again, one mustn't lose sight in my submission of the proportionality of this. We are talking about some admitted factual use. There is an issue about quantum, I entirely accept that. An undertaking has been given, and then 4 blog posts. That is the shape of that.
4 blog posts. I'm sorry, that's an inaccurate description of the 10-1 claim.
No, I accept the 10-1 claim is wider than the 4 blog posts, but the comparative advertising defence is run. My lord, I'm sorry.
Yes, all right, that's clear. Thank you.
So, now, my lord, the invalidity point, there is no plea to invalidate the mark. There is a plea that it is potentially bad under subsection C.
Well, you've said that's abandoned and that's the end of that.
Yes, that is. And my lord, the key point being it wasn't in the list of issues, so it's not within the funnel through which the case will be heard.
Sorry to interrupt. Just on that last point.
Yes.
Where in the IPEC small claims track rules
I
does
think
it
it's rule 63.23. But
Thank you.
let me see if we can get you a
No, that's very
reference to the
helpful.
guide.
Rule 63.23.
Yes,
I won't hold you to it, but
well,
and
my
that's
lord,
one
I'm
of the-
maybe to do better, but
Thank
those
you.
behind me maybe. Sorry? 0.29.
Thank you very much indeed.
Grateful to
And that the gist of that is that the list of issues define what
Yes,
the judge
but
has.
that's the list of issues determined by the judge. And the problem is, the judge didn't do a list of issues.
No, because
as far as
there
I
were
was-
2 competing lists of issues before the judge, and he decided the question of track allocation. He moved it to the small claims track, where it will then be judicially managed in that track.
But what that tells us is, because if you're relying on the rule, it's the rule applies to the list of issues determined by the judge at the case management conference, and that's never happened. So
No, my lord, but
from that perspective, there is no limitation on issues.
no, but the fact that my client has not put forward something as an issue in his proposal is it would be somewhat surprising if the judge then incorporated that, even though my
So
my
that's where
client
we
wasn't
get
pushing
into
it forward.
the difference between validity and 10-1, because validity, I take your point, it was on neither side's list of issues, and therefore you can say, all right, that's fallen by the wayside. But 10-1 is different because it's not in your client's list of issues, but it is in the claimant's list.
Yes, so there is something to be resolved. What is the proper scope of that case? But that's a question of management. In the spectrum of trademark infringement cases, one always used to think, subject to all of the rather difficult questions of trademark use and so on, Section 10.1, identical mark, identical goods, should be the most straightforward of the categories.
It should be, yes.
I mean, that is not, I don't make that submission against myself for the purposes of complexity, because this is a court track which is intended to encompass trademark cases. My own friend keeps on referring to the simple photographer case, but actually it isn't. There is even complexity within photography cases, because there are real issues, according to the Court of Justice, about whether there's even copyright in a banal photograph. So one has to have a court system that is capable of dealing with certain things. The thing we know for certain is that patent cases are not within this track, for a very good reason, because they often require experts, normally require an expert to give assistance to the court when it's considering questions of construction and infringement. But the solution to this is cannot be, all trademark cases are too complicated, therefore that's an inappropriate way forward. In my submission, one has to manage the track in the way that was intended by the introduction within through the rules in the civil procedure rules. Otherwise, that SI should not have been made. Joint tortfeasance was the other one my friend referred to. There, the facts are admitted. And there may need to be some argument about where that takes you.
Well, you say the facts are admitted, but there's an express denial of knowledge, and that's one of your list of issues.
Well,
and how is that not a fact?
The knowledge, yes, but the facts that are alleged, so it's paragraph 13 of our pleading. Page 262. So it's admitted that the second defendant is the controlling mind behind the first defendant and has responsibility and control for day-to-day management of the affairs of the first defendant. Factual account in paragraph 7 is admitted. And it was...
But paragraph 8 in your list of issues is whether the second defendant had knowledge of the essential features of the relevant tort, which is plainly the issue raised, as Mr. Edinburgh submitted,
Yes, in our...
by lifestyle and argument. And that's a question of fact, isn't it?
Well, that is, my lord, you'll see in 13.3, the allegation is denied for the reasons set out below, and then that refers essentially to the pleading on the substantive matters that there's no infringement. Now, I accept that on that list of issues, as my client put it forward, there is a potential issue there on joint tortfeasance. But again, that is something that can, in my submission, be dealt with as a question of fact. It is not justice in the small claims track and in a low value dispute doesn't have to, in my submission, be an exercise where there is an enormous amount of legal learning and jurisprudential debate. Often a judge will form a view on the facts as she hears them or he hears them from the evidence that they've heard before them. No doubt my client will be asked some questions about this and the judge will form a view. It is a way of dealing with these issues that is proportionate to the debate. And the difficulty with all of these submissions from my learned friend, and to a certain extent my answers to these points, is that we are turning the dispute into a more complicated dispute than it need otherwise be, to be adjudicated fairly and proportionately for the sum of money an issue. His Honour Judge Hacon, in the judgment under appeal, obviously looked at these points in the round and formed a view as to where he thought the nub of the case was. And that, to say, he was perfectly entitled to do. Now, damages. My learned friend made some submissions about convoyed goods. Convoyed goods is, my learned friend explained it, is not in the evidence, and it was not raised below as far as we can tell. There was then a debate with my Lord Justice Arnold about what's the position, how can you tell whether there is an automatically a lost sale as a result of the defendant selling something. Well, ultimately that's a question of causation. If there are 10 customers for a particular thing, and I sell to 3 of them, then you might have lost 3 sales. If there are 10 plus 3 customers, you might not have lost anything. It's a question for the court to assess. You may have just enlarged the market. And so to that extent, it is relevant to consider what is being sold and exactly as a matter of causation, what loss is caused. But again, this is inherent in any case where damages are to be assessed.
Well, part of the point of the reasonable royalty approach is that it avoids that problem.
Yes.
But then,
Yes, but then do you set it at 5 or 3 or 2 or 1?
Yeah.
And that's the question. And if you set it at, I can't remember where my learned friend
He said 1. He said 1%.
So he pitched just above. I think he said 11,000 at 3%.
No, he said £1, which he calculated with impressive skill on his feet, as ending up at about 3%.
Yeah. So my lord, I mean, this is a question for the judge to assess, but ultimately, even I think my learned friend referred to a figure of 11,000. That is not out with the scope of the small claims track. The 10,000 is not a jurisdictional cap, as we saw from the guide. It's just a guide as to what is appropriate for those kinds of cases. But again, my lord, what we say can't be right as a matter of principle is for my learned friend to come to on an appeal, or for this court to interfere, because there are other ways of potentially running a damages analysis, particularly in circumstances where points were not argued, and in particularly in circumstances where the claimant was on repeated notice that this was in dispute. On that, the judge is perfectly entitled to take a view as to whether there's anything in the point or not. So, my lords, I won't take you through the party skeletons, but it is quite striking if you look at the skeletons below, how some of these points are called out, particularly the defendant skeleton. There is a paragraph which is emboldened, where the defendant skeleton makes it clear there has been nothing produced. There is no explanation. Let me just get you the reference.
Well, since you've referred to it, let's have a look.
Yes, let me. I'm sorry, my lord. So it's in the supplemental bundle, tab 11, page 186. Paragraph 15. So I mean that was the gauntlet that was thrown down, and the judge was entitled to take a view of the materials before him in the light of the submissions, and then he gave an extempore judgment, which my lords have seen, obviously. Now, again, the duty to give reasons. There has been criticism made of that judgment, but it can't be right that when a judge is giving an extempore case management judgment, particularly a judge of experience in this particular court in this way, he has to give a judgment which it gives reasons so fully that it can be criticised in the way that my learned friend seems to suggest by way of omission. Not least because some of the points that he's developing on this appeal, which may or not be good points in law, for example the Blaney point, were not just simply not argued before the judge. He said at one stage Blaney wasn't cited by the judge. Well, that's hardly surprising because it wasn't the subject of submissions. But again, that is not that cannot be the correct approach, because otherwise you tie up these kind of case management decisions in knots and give a way through, because whatever is done, it's an impossible job for the judge hearing them at first instance. So, my lord, those are the key points that we make. I mean, obviously, you have my points on the skeleton arguments in relation to how we say that that actually the judge is perfectly entitled to form a view, and that he did. So those are the points on the first ground. If I could turn, my lords, if I may turn to the second ground. My own friend there was asked why this point was not raised below. He does in paragraph 4 of his skeleton argument address that slightly, which is essentially, he says there was no point arguing it because of Tumber.
I understand that to be a retrospective.
Yes, my lord, I don't need to get into the genealogy of the point in that sense, or I'm not going to get involved in discussions about whether it should or shouldn't have been taken like that. But it is a new point. Now, how do you actually go about deciding this? You've got to take a view, and I'll come on to the authority UVP in a moment. You have to take a view on what reasonable costs are in the market for small claims track cases. Worth less than 10,000, maybe worth 5,000, maybe 500. If it's a £5,000 case, proportionate costs must be a lot less than that, maybe 1,000. If it's a £300 case, maybe what's proportionate is even less. How on earth is this court to assess where that figure should be put? That is a question ultimately for the Civil Procedure Rule Committee for delegated legislation? Is it reasonable for a party to instruct city solicitors on such a case? Well, as I'll observe, sometimes you might want leading counsel and junior counsel because it raises a point of principle which that particular defendant doesn't want to let through. But again, how are you to assess what is reasonable in those circumstances without forming a prejudgment about where the reasonable costs sit? And that is the difficulty about raising this point on appeal in this way, because there's been
that difficulty would have been exactly the same below.
It would have, there may have been an opportunity to put evidence and respond to it as to what the market rates are for certain things or what's normally charged on these sorts of appeals. But actually, my main submission is that this is not really a point for parties to be raising, and this is perhaps direct effect, horizontal direct effect manifestation. There can't, when you actually start to look through the consequence of running this point, the court has to adjudicate questions which are actually quite tricky, and they're broadly legislative questions. And that is why.
Yeah, but that's a perfectly valid argument, whether the point was taken below or not. It's a different argument.
No, it is. I mean, it's a related but different argument. I accept that. Yeah. Now, United Video Properties and the Enforcement Directive. In my submission, it's important we have to work through that a little bit in stages. Now, the point of the Enforcement Directive was that lots of different member states back in the early 2000s had different levels of IP divergent approaches in their national laws as to enforcing IP rights. So the Commission intended, the legislature intended, to harmonise up their forms of protection. And actually what they ended up with was, to a certain extent, a sort of hybrid of UK approaches, French approaches, and some other continental approaches. And so there are measures relating to evidence and so on. For our purpose, the key point is the Article 14, which you find, if I may just take you there, page 224 of the bundle. Which is I'm grateful, thank you, tab 9. Where it is, tab 10. Yes, page 224. Article 14 sits at the bottom, so it's in section 6, damages and legal costs. Article 13 sets out various principles that have to be taken into account when assessing damages, and that is something that the United Kingdom took a decision to implement various aspects of that. Article 14 provides that member states shall ensure that reasonable and proportionate legal costs and other expenses incurred by the successful party shall, as a general rule, be borne by the unsuccessful party unless equity does not allow this. Now, so it requires member states to have, as a general rule, cost shifting. The winner recovers some form of costs, potentially. But the rule is not said to be inflexible. It's a general rule that can be disapplied where equity does not allow it. And equity, for these purposes,
yes, but the Court of Justice said in UVP that means on a case-by-case basis.
Yes, questions of fairness, and that's what we know from UVP. Now, there is nothing in the recitals or elsewhere in the directive that tells you what reasonable or proportionate means, and whether it has any special meaning. And so it doesn't on its face specify how member states are to go about implementing that objective. It's, as it were, a sort of aspirational provision. It doesn't say whether this has to be done on a case-by-case basis, or whether it's legitimate for a member state to do that, or whether it's to be done in some other way. What is open to the member states is to have a regime where cases are put into certain categories, buckets, if you were, depending on their value and other factors, such as complexity and fairness to the nature of the parties and so on, and then to have fixed costs within those particular categories. or a member state could choose to keep the whole thing at large and have determine everything on a case-by-case basis as the cases go through. Or you could have some hybrid of the two in different ways. So on the face of the article, as the Commission observed in UVP, there is a lot of member state discretion as to how to do this. And there has to be, because this court systems were very varied across different member states, and there has to be flexibility as to how member states implement these sorts of provisions through their particular domestic legal systems. A district court in Greece may work in a very different way to a district court in Belgium or Estonia or wherever it is.
Can I just check? I mean, in UVT, the Antwerp court never had any system for more sophisticated disputes getting higher costs. It was all subject to the flat rate, wasn't it?
So that was the very striking thing about the Belgian system, because the 10,000. So the way that point arose in UVP was that having discontinued the invalidity action on the patent, they were stuck on 10,000. I can't, if I may, I'll come through.
It was actually 11,000 because of the adjustment for inflation, and by the time it was ultimately decided, it was 12,000. But the point is the same.
Yes, I'm not sure if my lord heard the English. I couldn't quite work out from the reported cases whether you had heard the English limb of the same patent or not. Several years ago, but anyway, it was heavy patent litigation, and so that was the background. Okay. Now, as my lords have already heard, well, actually, just while we're on the directive, if we could just look at page 225. So the way the directives work is that under the treaty, member states are obliged to implement their provisions. Page 225, Article 20 requires them to do so by a particular fixed date, and then they have to tell the Commission. If they don't do it, if what they've done is unsatisfactory, the Commission goes off and starts proceedings against them in the Court of Justice. So that's the first mechanism to keep member states in line. In fact, as far as the enforcement directives are concerned, there were quite a few of those proceedings kicked off. It's very difficult to tell what they were actually about because of the way that they're recorded in the official journal, but we know that some of them were started. Now, as far as the United Kingdom was concerned, we did have to implement certain aspects of this directive, and that was done through the Intellectual Property Enforcement Regulations 2006. But as my lords have heard, no implementation for Article 14. And then 6 years later, there was a Civil Procedure Rules amendment to introduce the small claims track. Now, we've drawn out a couple of aspects of the background to that, but one of the points that we draw out in our skeleton argument at pages 5 to 6 is that that part of the rationale was to improve access to justice because costs will be proportionate to what is at stake. And so this is the bucket approach, essentially, to put it colloquially. You decide a prejudged category of case, and then you make a decision about what is proportionate in the circumstances of those cases that properly fall into the bucket. Now, my lords have already heard about the Tumber case. The point about the Tumber case, where His Honour Judge Hacon had argument on this previously, was that what he was saying, in effect, maybe I should turn up the judgment. Tab 2, page 29. Tumber was a case about Mr. Tumber had, just by way of background, had composed the longest love poem, which apparently ran to 244 lines. It was picked up by ITV News and various other people, and then ITV popped it on their website, and Mr. Tumber wanted to bring proceedings to stop that. They took it down after 24 hours, but the question is, how did one approach those proceedings? And you'll see at page 29 over to page 30 his decision in relation to United Video Properties. So it was raised by the parties before him there. Page 30, he says, well, there's no issue relating to a technical advisor, so that's a category of costs that was obviously germane to UVP. But the whole purpose, as he records in paragraph 30, is that it would be unusual for payments of the cost to be appropriate, provides a low-cost forum, which is undoubtedly in the public interest, The rules also provide for payment of costs by a successful party in circumstances which, in the view of the IPEC Small Claims Court, are appropriate.
But is that correct statement? Because 27.14, Rule 27.14, is directive. It's mandatory. It says shall not. So the court has no discretion to award costs.
Well, unless it's a case which takes it out, in the court's view, that takes it out of the regime, because I think if it's I can't remember the exact.
Well, except where there's unreasonable behaviour.
Unreasonable behaviour, my lord. Yes. But the costs in question are costs not only they are costs relating to the issue of the claim. You get slightly more, I think, under that regime if you're asking for an injunction.
You can have £260 for legal advice if you're claiming an injunction. That's it.
Yes. Well, my lord, but that's, as I say, if the value of the claim, that is a decision that has been made to allocate cases to that, plus the issue fee for the case, plus the reasonable expenses of witnesses attending, which I understand can sometimes be not insignificant. But those, I accept those are the scale costs unless it is an exceptional case. So the point being, the way to read that in my submission is that it's the costs and disbursements by a reasonable party, i.e. the cost of bringing the litigation. Sure, they are capped, but that is an appropriate thing in my submission to do, and it can be fully proportionate to do it in a low-value case. For all the reasons that I've already addressed you on, that it improves access to justice by prejudging what are the proportionate costs.
And how do you deal with Mr. Saunders' point, which is where he says, well, I flip it and look at the fact that we've got two represented parties and feeds it back, I think, into ground one to say that really this has got nothing to do with a sort of small claims track?
Well, my lord, I think certainly there can't be a prohibition on a party seeking obtaining legal representation and using it. That must be right as a general principle of law. It's for the party to decide whether or not it needs it. If, as my lord observed earlier on, if all you have to do if you want to bounce yourself out of the small claims track is to go off and instruct a lawyer, and that can't again be an appropriate test for the purposes of whether it is proportionate and reasonable, and also the policy reasons which we've seen for having this court, and also one which is consistent with the requirements of the overriding objective to allocate an appropriate share of the court's resources more generally. If there is a low cost claim which doesn't raise important points of principle or affect third parties, then the court should be able to manage that in a way that doesn't result in jaundice on jaundice. There was a famous quote, I forget which case it is, about someone saying they'd rather catch influenza than fight a patent dispute. But intellectual property cases can sometimes morph into things which are disproportionate to the value of the claim, and this is a way of controlling that. Now, so far so good, but what we have is Article 14 lurking out there. It has not been implemented into domestic legislation. So where does that leave us? The question of direct effect, my own friend clarified he's not relying on horizontal direct effect, he can't. My Lord Justice Arnold identified the case of reprobel. My Lord, I won't...
Yeah, but in the end that didn't go anywhere because Mr. Edinburgh clarified that although it said Article 14 did have direct effect, he accepted that his client could not rely upon that because they were not an emanation of the state.
That's exactly
Sorry,
so.
your clients are not an emanation of the state.
No. So reprobel was a case in part about whether the reprobel, the collecting society, was, as it were, a tentacle of the Belgian state, and so therefore should be subject to direct effect. The other point about reprobel is it is a very recent decision, relatively speaking, and there have been a whole series of references on private copying which have somewhat de-Delphicized the scope of that provision. what is quite striking about the private copying exception is that when the United Kingdom itself put in a provision in relation to private copying, that was then the subject of a judicial review, and ultimately was quashed by Mr. Justice Green, as he then was. But despite the best attempts of counsel for the Secretary of State to preserve that, one of the things Mr. Justice Green had to consider was whether there was in fact direct effect of Article 52B, the same article in referral. He concluded in that decision that there was not, as a matter of domestic law. I haven't got the authority, but it's 2015 RPC 6, paragraph 160 onwards. So, he cited copy down and Amazon and so on. But what there hadn't been at that stage in time was the other series of subsequent decisions, which, as you see from Advocate General Spooner in Reprobel, meant that that article had been rather more precisely demarcated, and so therefore the court could conclude that it hit the test. So that's Reprobel. We say not of obviously a recent statement of the law, which is still the same law as Van Gent, but expressed through that case. But the critical thing is Reprobel certainly does not establish that there can be horizontal direct effect of an unimplemented directive. My lords, if I may, I'll just address you on Brexit, and then I'll just turn to the decision. So we have an unimplemented provision of a directive, and we have the UVP decision. Under the EU Withdrawal Act 2018, Section 1 of that repealed the European Communities Act, and so unless things were saved, all legislation in the United Kingdom that had been implemented in order to give effect to directives would disappear in a puff of smoke. And so we then have a series of provisions in that Act that save certain aspects of that legislation. And if I can just turn that up very briefly. So it's tab 11 of the authorities, page 230.
Two three zero.
230.
Thank you.
Section 2 at the bottom of the page. So Section 1 on page 227 repeals the entirety of the European Communities Act 1972, which is the power through which all this legislation took effect. Section 2 is a saving for EU-derived domestic legislation. So that is domestic legislation that is derived from a directive, amongst other things, and provides that it continues to have an effect in domestic law on or after, you'll see the amendment there, IP completion date, and part of that was because Brexit was extended to the implementation period completion. Now, so if something had been made under Section 2 of the European Communities Act, it was saved. But what this Act does not do is save unimplemented bits of a directive, because there is no general incorporation into the corpus of our law, and I'll come on in a moment to Section 4, but there is no general incorporation into the corpus of our law.
Direct effect was preserved in the original version.
Yes,
but that's now gone.
That's right, my lord. And but direct effect is actually preserved in a rather more limited way. So I can hand up, if you turn to page 233, I'm afraid the version of the Act, the Westlaw annotation has chopped the relevant bit. If I can just pass up, the bit of. So this is the old version of Section 4 before it was amended out. And the Section 4, subsection 2, just at the bottom of that page, you'll see does not apply to any rights, powers, etc. so far as they, and then B, arise under an EU directive and are not of a kind recognised by the European Court or any court or tribunal in the United Kingdom in a case decided before IP completion date. Now, the explanatory notes to that Act explained that that was intended to ensure that that cases matters having direct effect could be relied upon where a court had recognised prior to exit day that they were to be interpreted in that way. So the freezing of direct effect is freezing of things that were recognised, not a general freezing. So if you have a provision, even if it were directly effective, and it has to be directly effective in a way that can be relied upon, and it wasn't recognised as such, it died as a result of the EU Withdrawal Act. And then, as my learned friend, as my Lord Justice Arnold identified, we then have the retained EU law Revocation and Reform Act 2023.
Just before you go to that, was there any case after UVP and before Brexit Day where this point had been taken?
My Lord, no, not where it's recognised that there's a direct effect.
Thank you.
There have been other cases on the enforcement directive. I should make that clear. But certainly the case has come up in the enforcement directive has come up a number of times in domestic courts as well, where we've implemented aspects of it. But not this. So then we have to go to, if we just go over the tab in the bundle to page 247. So we have the 2023 Act. Now, leaving aside the rather unhelpful terminology change from retained to assimilated, which quite understands why it was done. Section 4, which we were just looking at, has been sunsetted, as it's described in paragraph in section 2, and so it has no effect. It's repealed from the end of 2023. Now, so not only is there no horizontal direct effect from an unimplemented directive, even if that's wrong, and there was in some way something that could be relied upon, it wasn't recognised. It didn't get through the EU Withdrawal Act, and even if it hadn't got through, it was killed again by Section 2. So, as Mr. John Cleese put it, it's dead, definitely dead. Has gone to sing with the choirs in the sky, that particular provision, or perhaps in Brussels.
So your analysis means that it died on Brexit Day, 31st December 2020, rather
on
than
IP
later.
completion day, that's right, because it was never absorbed through the Withdrawal Act. But even if that's wrong, it was definitely repealed at the end of 2023. Now, my learned friend in his submissions said that he wants to run this as a Mar-leasing type interpretation point. Well, first point in relation to that is that when the amendments to the civil procedure rules were introduced, they were not intended in any way to implement anything to do with this. At best, they were, as far as we can tell from the materials.
That wouldn't be an obstacle to what Mar-leasing.
No, my lord, I accept that as a matter of principle. But the effect of Section 2 is that Mar-leasing type arguments have also gone. Now, I think there is authority on this, which may be Fry, which was a case which Lord Justice Arnold considered recently. There is also another case called E-Accounting Solutions and Global Emphasis, 2023 EWHC 2038. Which I think holds that Mar-leasing is no longer part of domestic law following Section 2. My Lord, I'm afraid I don't have either of those in court because I wasn't really anticipating the argument to go like that. But if it is...
I have to say, I thought it was a result of Section 4, but ruler, but I don't think it matters.
No, well, so Section 4 also abolishes any general principles. I'm sorry, my Lord, I misspoke. I think it is Section 4, isn't it? 4.2b. That's right, my lord, I apologise. So Section 2 gets rid of Section 4 of the predecessor Act.
Yeah.
Section 4 of the Revocation and Reform Act 2023 gets rid of the general principles. Yeah. And as I say, I think it's E-Accounting Solutions and Global Emphasis is the authority on that. Possibly also Fry, but I'm afraid they don't have those in court right now. So we say, however you look at this, it's very difficult to see how this is a point which, I mean, I hesitate to call it an actual Brexit benefit possibly, but it is at least something which means that argument on these sorts of points, a springing argument from EU law in relation to something that was not implemented, doesn't survive the legislative changes that we've had. So that's the first point in relation to that. Second point is obviously the actual UVP decision itself. Well, we've set out a number of submissions in relation to how that should be approached in our skeleton argument. But
your primary point is Article 14 cannot be relied on, which means you don't need to worry.
my lord, yes. I mean, just in case for some reason you're not with me on that, you've got my submissions in the skeleton argument about the actual case itself. The key point about the actual decision in UVP is that it does not preclude this sort of decision to make court tracks in buckets with decisions about costs. Where the vice possibly lies is where there is for example, as in that case itself, a very significant amount of expenditure, which is something that then gets sucked through. And that was, on its facts, a very, very different case to the present. But either way, we would submit that there is no principle of law which is engaged such that it can be said that this decision, that an additional factor has to be taken into account when considering these questions of track allocation for both of those reasons. The case does not preclude taking a view that a proportionised bucket-based system is a legitimate way forward.
Okay, is that a convenient place to break off?
Yes, my lord, I'm grateful. I don't expect to be much longer unless my lords have questions for us. But obviously my learned friend will want to reply.
Let's see if we can finish before lunch.
To help you with that decision, my lord, I would be about 5 to 7 minutes. I've got just bullet points to make.
Shall we do it?
Fine by me.
But if everyone's happy to carry on, yes, right.
Well, my lords, could I just check? That's possibly the time for me to sit down, but if I could just, there's nothing else. That's my lords.
You're done.
My submission.
Thank you very much. Yes, Mr. Eden.
Having now committed myself,
Yes.
the first point is, my lord, you mentioned that the principal solicitor instructing me his hourly rate is 1100. If you notice on the cost schedule, he's only charged 0.3 hours.
Yeah.
So he's the supervising solicitor and he's exercised his supervising role. The second point is with respect to the list of issues and how they are treated in IPEC. You can get some indication of that from the IPEC guide, which is in the authorities bundle behind tab 13 on page 296. Under little paragraph C, and it goes down and then it says the issues, and that sets out how the IPEC court treats list of issues and issues raised in the pleadings. My learned friend mentioned about the undertakings.
Sorry,
my lord.
what does it say? I've got as far as writing down page 296.
Sorry, my lord. I was just trying to give you bullet points. The point is that it's a little bit more dynamic than my learned friend tried to say. You look at the pleadings and you look at the list of issues, but in particular, you're not supposed to detail every sub point.
Right. Thank you.
So you can be a bit more global, and there's a bit of leeway.
Well, in particular, what it says is the parties will be permitted to argue at trial any point which is both covered by the pleadings and which the opposing side should reasonably contemplating within one or more of the listed issues.
Which would cover section 10.1, for example.
Yes.
And before the invalidity was formally withdrawn before your lordships here, it would certainly cover the way in which invalidity was raised as a matter of defence. My learned friend mentioned about undertakings with respect to, I think it was 10.1, but you ought to know that no undertakings have been forthcoming in writing. So it's been mentioned orally, but it hasn't.
Recorded in the judgment. Why isn't that good enough?
Well, because the exact wording of the undertaking hasn't been recorded. There's another point here that the way in which the argument was put with respect to low value seemed to be suggesting that if the case is of low value, it must go to the SCT. Because if it's only of low value, then it's always only proportionate toward no costs. That cannot be right in cases where the notional value is very low, but they go to full trials in front of a chancery judge. An archetypical example of that would be the Amazon case, where the notional value of the case was $5,000 US.
And it ended up in the Supreme Court. Yeah.
Exactly. I do say notional because there's a dispute about how much it was actually worth, but that was the value on the pleadings. And that must be the wrong way of looking at it. You have to take into account the complexity of the case. There was a point about lost sales, and it was raised about whether or not lost sales would result in any loss and damage, and there's a causation issue. That, of course, means that there's going to be evidence of that, and that's another issue of complexity. Just to make sure there was no ambiguity, when I mentioned the £1 royalty, that was £1 per unit.
Yes, I'd mistaken that.
Yeah, that's right.
But my lord had it right.
Yes, exactly. That's all I need to say on that. And then there's a point about representation, and that was actually discussed by His Honour Judge Hacon in the Turber case, which you can see in the authorities bundle behind tab 2 at page 30. And it was paragraph 32. I can just leave your lordships to read that, but it deals with the issue of whether or not you can force your way in or out of the SCT by electing to be represented or not represented. And so the judge was alive to that issue in that case. Well, Lord, those are my 7 minutes, unless I'm asked. All right, sorry, I've been told there is now undertakings in writing. 18th of March, 2025. Sorry, the last thing I saw on that expressly said it had not been done.
All right, but that's now been dealt with.
Yeah.
Very good.
Sorry, I'm sorry about misleading the court on that. My lords, any questions? He says optimistically.
No. Thank you very much. Richard, should we see? Yes. Well, Mr. Edinburgh, Mr. Saunders, thank you both very much. We will reserve judgments in this case. In the usual way, drafts will be circulated for counsel to assist with correcting typos, etc. And in the light of the draft, we'd be grateful if the parties would endeavour to agree an order, any consequential matters. If there's anything which can't be agreed, please make brief written submissions on each side, and we'll aim to resolve those without a further hearing unless it becomes necessary for some reason. Thank you both very much indeed, and those behind you for your assistance. Please don't feel constrained to stand to attention whilst I make my very slow way out.